Welcome to the Hastings Shadmehry Show with your hosts, Andee Hastings and Mally Shadmehry. Dive into the heart of family law as Andee and Mally bring clarity to legal challenges, celebrate client victories, and share the wisdom of their combined expertise. Get ready for a journey into empowerment and advocacy right here where your story matters.
Hello, and welcome to the Hastings Shadmehry Show, where we delve into the heart of family law and the stories that shape our lives. I'm Mally Shadmehry, and joining me is my partner in crime, Andee Hastings. How are you, Andee?
I am great, Mally. How are you?
I am doing well. I'm ready to take on the day, crush this topic, educate our people. But first, I just need to know, are you feeling more like a warrior or a diplomat today? And why?
Warrior.
Oh, she was quick on that. Okay, tell us why.
So we have a lot of people who have held fast through the holidays for their kids or their families, and now they're coming to us wanting to move forward. And I'm just seeing a lot of forms of abuse, and you know how I am about that. It's like in my DNA to be very aggressive when it comes to people being abused and protecting them. So that's just where I am right now.
Love it. Andee is a protector, and we all get to benefit from that here. You're a protector not only with our clients, but our staff, our employees here, me as your partner, my dogs. Everybody's safe with Aunt Andee, as my dogs call her. Okay, for me, definitely warrior. No surprise. For the same reason, honestly. People held fast, like you said, through the holidays, and they've now are coming and saying, I'm ready, help. And to hear some of the stories I've been hearing in my consultations of what people have been through, I'm like, oh, let's go. Oh, let's go. I'm ready. So that's the mindset in this office today. I don't know about yours. All righty. So today we are talking about a really popular thing that our people come to us and want to know about. And that is, how much does my child actually get a say in who gets custody of them? Do the children have a say in where they go in this case? And what does that look like? So let's just generally give a primer on how we feel about this. And then we'll talk about some specific kind of protocol that the law allows in Georgia for this. So tell me, Andee, in no uncertain terms, how do we feel about children being involved in the litigation here?
We hate it.
Yeah.
I did that without any expletives. I need some props for that. We absolutely hate it. Judges hate it. Please do not, under any circumstances, involve your children in litigation. And it comes up in a variety of different ways, but we hate it.
Okay, so now y'all know where we stand on that. So there's a fine line when the case is beginning, and obviously children are very intelligent, they're resilient, and they pick up on things. They know what the environment at home looks like. You obviously have to have conversations with your children when the family dynamic is shifting, and there's responsible ways to do that, and there's irresponsible ways to do that. And do not forget that I told you this. If you handle it in an irresponsible way, you are risking losing custody of your child. Under the best interest of the child statute in Georgia, 1993, a court is going to look at how you are acting with your children while this case is pending. And did you handle these adult conversations in responsible ways? Because the underlying sort of thought is, let your kids be kids. Let's still foster their development. Children are biologically, as humans, we are wired in a way where we know that I am half mom and half dad. And when they're living in an environment where mom or dad has coached the child or put ideas in the child's mind, or the child's overheard mom or dad on the phone with their buddy saying, oh my God, my spouse is just a piece of shit, whatever. Like, that's going to get ingrained in the child's mind. And the child knows, well, dad is half me. And if dad's a piece of, you know what, then am I? These are messages we start sending unintentionally. Okay, so all this to say, you need to be working with a therapist, probably, and your children need to be in therapy so that everybody, the whole family, ideally, is on the same page about how we send this message to the children of mom and dad are divorcing and what that looks like. I've had many clients that have involved the children way too much. I've had the other side do that. What does that look like, Andee, when a child's been involved too much in litigation? How do we know? What do we look like?
So it depends on a lot of factors. First of all is the age of the child. The younger the child, the more inappropriate that it is. It's inappropriate at any age to involve children. But truly, the younger they are, the less they really understand about adult things, and the greater your responsibility as parents to ensure that they don't understand those things, not at this point in time. They're not your sounding board. They're not your ally. They're not there to support you in your divorce. You're there to support them in your divorce. And something that we see with children, I think, is, especially younger ones, if they're being coached or they're getting too much information related to the divorce case or about the other parent and that sort of thing, is they start, well, one thing they'll do is they'll start acting out.
Yeah.
They'll act out in school. Because they don't know where to put their emotions. And so they express it in the only way they really know. The other thing is that they'll start talking about adult topics in ways that don't make sense for example, a 5-year-old to use certain words and talk about things. It gives you a clue that somebody is talking in the presence of your child or to your child about things that they shouldn't.
Yeah, and I think it's a common kind of thing people don't talk about is that you might not be directly talking to your child about the case, but they are overhearing your conversations. So be very careful about that. I've seen some of the worst parents having a kid on camera and being dumb enough to do it on camera, and I've seen it as evidence in the case where they say, "All right, now tell daddy again, who do you want to live with? Who do you want to live with?" And then they think they're going to use that in the case. That is going to backfire. That is just, I consider it a form of mental abuse on a child. I really do. That's a personal thing in my head. I just think that that's so inappropriate. And a lot of times our clients will say, well, what do I do when my kid comes and says, well, daddy said this, mommy said this about the divorce, the other parties being inappropriate, or they've just heard something and they're asking questions. And what I always say, number one, we really need a therapist involved. Number two, we need the therapist so that the child has an outlet. That's a third party, not a parent, where guilt can start to, come into play for a child having these conversations with a parent. They're seeing their family split off into different directions. They're going to learn what a new healthy family dynamic looks like. But that is really hard to establish without a therapist helping get them in that mindset. It's not the parent's job to be doing that. And frankly, when you are going through a divorce as the parent, you are not emotionally stable. You're just not. That comes from us seeing this for many years of experience. You are in a place where you need to be working on yourself, handling from a business side of things what we're doing with the financials, and not adding to your child your emotional instability. And you may think that you've coped, you've mourned the marriage, you're done. Okay, but no, you're not yet. You haven't started your new chapter yet. This is why lawyers exist. We're there to help get you through it. So what you say and what I recommend when a child's bringing things up and you feel forced to have a conversation about it, that happens a lot, especially with older children. And I mean, I have had really intelligent 5-year-olds in cases that ask very prudent things. And what you have to say, that you have to not play dumb. You're not going to have to lie to your child. But what you have to say is, look, all you need to worry about right now is that mom and dad both love you so much. Even if you don't want to say that to your kid, you better say that to your kid. I don't ever want to hear that, mommy loves you. Okay? And no. We're not going to create that illusion for a child. You will look disgusting in court if you act like that.
How about mommy's the reason that we're not going to live together as a family?
Oh my God.
Or daddy has decided that he loves somebody else.
Yeah.
So this is none of that. They are not the conduit through which you vent your emotional issues with the divorce. And they are not to be brought on as allies, because what people may or may not realize when they make comments like that is that's what you're trying to do. You're trying to marshal your child as an ally in this battle that is your divorce.
Yep.
And you've got to break yourself out of that mindset, because it's damaging for your child, most importantly. And it's also going to be damaging for your case, because when a judge, or let's say a guardian ad litem, looks at this case and is performing an investigation into what's in the children's best interests, they're going to look at that in a very negative light. And folks seem to sometimes feel that, well, because they feel that way and it's justified factually, it's justified to say. don't fall in that trap,
Yep.
because it's one of the biggest mistakes I think that people make.
Yes, and children will pick up on it eventually, whether that's during this case or when they hit 20 years old as adults and they start to have more autonomy with their emotional health and understanding of their psyche and things like that. It's going to backfire if you are one of those, or you see your spouse doing this. That happens a lot in my cases too. They're like, "Oh my God, my spouse is doing this, trying to win the child over." I always say, your kid's going to figure that out eventually. It may not be today, but long term, what that's going to do to their relationship, none of this is worth it. But so what I was saying is, what do you say when your kid's coming to you with stuff? You say, "Mommy and Daddy both love you so much, and you don't need to worry about this right now. You need to go be a kid, go make good grades, go play your sports, go play with your friends. We will update you at the right time, but right now, go be a kid. We love you." That is the messaging you need to be sending, point blank, period, and no one could convince me of otherwise.
I completely agree. And like you mentioned a moment ago, Mally, I think sometimes parents, because they're so upset, and rightfully so, about the divorce and the circumstances surrounding it, it's hard for them to utter those words. And all we'll say in that moment is just put your kid first. You've got to put your kid first above your emotion in that moment, because what we have experienced in doing this for so many years is you're creating a safe space for your child emotionally while all this turmoil is going on. And children remember that, whether or not they're old enough to be cognizant of the fact that you were the one that was their safe place. They didn't feel like they had to choose sides with you because you made sure they knew that both parents love them. That will carry on regardless of who, anything else that goes on in the divorce case. So never forget that your job is to create a safe space for them at all times, even when you don't feel safe yourself.
One story that I can remember, it was just so bad. When coaching and talking to a child and trying to convince a child to not like the other parent gets to a certain point, it's called parental alienation. That's for a different talk on a different day, because it's just it's a hot topic and it's highly specialized and nuanced. But I mean, I will never forget one time I had to cross-examine a 12-year-old little kid. A 12-year-old little kid. The other side chose to put him up. I would never want a child to testify. They do sometimes. A lot of times judges will take them in the judge's chambers, the judge's office, to talk to them and ask questions instead of the kid sitting on the stand. But in this particular one, this kid is just sitting on the stand, and he had been so alienated. He had turned against his mom because dad had put this information in his head. The kid had actually physically attacked my client. His mind had been poisoned. And the dad had been showing him credit card statements saying, "Look what your mom spent. Look at this. Ooh, let's look at your mom's, the people locator on Apple. I don't know, find my iPhone, whatever." They could see where she was driving, and the kid would text his mom, be like, "Mom, why are you driving 80 miles per hour on 400? And the dad was having the kid do surveillance on this kid, and I'm cross-examining the child, having to get him to talk about all this. And this kid was like, "No, my dad showed me all that. My mom shouldn't be spending money on plane tickets." And it's just, this kid's relationship with his mom is forever going to be something that they have to work on. Y'all should have seen the judge with that. The other side kept objecting, are you going to, don't let her ask this stuff to this kid. And the judge was like, "No, I want to hear this." And at one point, the kid started referring to my client by her first name.
Oh.
And I said to the kid, I'm like, so-and-so, when did you first start calling your mom by her first name? And they're objecting, and the judge is like, no, I would love to hear this. So if that gives you any idea, if you want a bad day in court, you're going to experience that if you've involved your kid in this litigation. But with that said, there are, at least in Georgia, there are a couple avenues under the law where kids can be involved and they can have a say. They can have a voice. I know that's sort of contrary to what we just said. So what I would say is, although the law allows for a kid to have a say, and we're about to describe what that looks like, it's really one of my most commonly asked questions, even though the law provides for this, what we're about to talk to you, I think that what we're going to see is that eventually this gets phased out of the law. I think our legislature is going to start to get away from this. I think across the board, what we're about to explain is not really something that's widely respected. In fact, in my experience, it's become frowned upon when and if you ever involve your children and try to give them a voice, even though the law allows it. So, Andee, could you kind of give us what the landscape is for the law on what I'm talking about?
Absolutely. So in Georgia law, when your child reaches the age of 14, they have the ability to elect what they want with regard to parenting time with each parent. And that may be something as simple as, I want to spend equal time with both my parents. It doesn't have to be super involved, but they do have a right to elect. And that is it's recognized when, if they do what's called an affidavit of election, the court will consider that and give great weight to that, potentially.
But doesn't have to adopt it if it
does not
found not to be in the child's best interest.
Exactly.
In my experience, I've had judges turn down those affidavits of election more often than adopting them, because they usually find that there's been coaching and these kids felt like that they had to go sign this.
Well, and something that we do if the party on the other side has gotten their child to elect is we may ask for the court to appoint what's called a guardian ad litem, who performs an investigation in order to determine what's in the children's best interest. And sometimes we'll even do it for the limited purpose of investigating, is this election voluntarily made? What are the circumstances surrounding it, so that they can dig in and have a conversation with the child that's neutral. It's not with either parent, and God forbid that parent's lawyer, because that happens. And so sometimes we'll do that if we're on the other side of that. And that, I find, is when guardians can really get in there and find out, this isn't what it looks like. And this child did feel pressured, but they didn't feel like they could say anything other than what's contained in the affidavit.
So, okay, yes. So the affidavit of election in Georgia, that's for kids that are 14 and older. The court is, under the Georgia law, the court's going to give a lot of deference to that, but doesn't have to adopt it. But then we also have what's called an affidavit of preference, which is given a little less deference. The court's going to take it a little less seriously, if you will, when a kid is age 11 to 14. And what I say in that scenario is, only time I've ever used those is really when there's already an older child who's doing an affidavit of election, and we've got some younger kids that, you know, they're old enough to conceptualize things. They're intelligent children. They'll kind of ride the coattails of the older child and do an affidavit in tandem with the older one. But it's just stupid. I don't know how else to say it. It's not good.
And also, don't you find that practically judges want to keep children together? So let's say an older child has executed an affidavit. It's not necessary to involve the younger child to do it as well. So sorry, y'all. Winter weather. Because that's sort of the general go-to with children, is that you want to keep them together. You want them to have pretty much the same schedule, unless there's specific reasons in a specific case. Why not?
Yeah, would be very, very specific. I haven't done affidavit of election or preference in any of my cases for many years. Because I would say over the past 8 years in my mind, I've seen the affidavits of election and affidavit of preference become less and less respected in the courtroom, almost on a yearly basis. It's like we continuously see it just go out the door, and it loses respect. And sort of the last kind of topic that correlates to this is that when and if affidavits of election, affidavits of preference get in the case, and when and if we've got issues pertaining to parental alienation, children being involved in the litigation too much, those are the expensive cases. Those are I've had many cases where I would say $200,000 was added to the bill for my client just based on those issues alone, having to weed through that, having to rehabilitate a client because they did involve a kid too much, having to show that someone else has involved a kid too much. And that's just something to be thinking about. If you want an expensive divorce, involve your kids in the litigation.
Completely agree. And my experience has been similar. So the footnote to all of this is, please do not involve your children in your divorce case. Whatever you do, no matter where you are emotionally, please don't do it.
And I agree. Thank you guys so much for joining us, and we'll see you again next time.